Let's talk about copyright in the age of AI. And today we are talking with everybody's favorite IP and entertainment lawyer, Tony. We're going to be breaking down what you need to know in the world of artificial intelligence, how you can use it with your content creation, your live streaming, and what it means from a legal perspective. Because if you've been paying attention, you will know there are things we need to be discussing. If you've got questions, now is the time to go ahead and drop those down below for us. Tony is going to be answering those as we go, and we are going to be talking all about, from a legal perspective, how you can be using artificial intelligence. Today is the kickoff for the 7th birthday of Be Live. We are so
Mm.
excited today. We are celebrating today and all week long. We've got some giveaways going on right now. We are actually giving away, and I'm so excited about this, a free live streaming mentorship session with Grant Saunders. He is an amazing person here connected to Be Live. He's actually going to be joining us for one of our later streams as well. And we are going to be giving away a mentorship with him today. And we are so excited to be having today's conversation. You can win this mentorship by leaving comments down below. So we want you to get into our comments and drop those for us right now. We are going to be collecting them here. And at the end, we're going to be doing our giveaway. And if you want to win as well without winning this session, everybody's winning today because Be Live is giving away 2 years of Be Live live streaming for the price of one. We've dropped the link into the comments. You can check that out. That is happening all week long as we continue to have our conversations with our guests, just like Tony. Tony, we're so excited to have you here. How are you?
I'm doing great, and happy birthday, Be Live. I was part of this last year, and of course, it's great to be back. And of course, talk all things copyright, especially with artificial intelligence. But I have to say, in light of the discussion, I decided to pick the most copyrightable asset ever, Mickey Mouse, although it's a little bit reverse here, but Mickey Mouse, you could definitely tell, and of course, Minnie. And today is the 100th anniversary of Disney. So I get a twofer here. I had to basically kill two birds with one stone.
I love it. And we get to celebrate the 100th anniversary of Disney, and we get to celebrate with you. You actually work with the mouse. And we're really excited because we are going to have a lot of really great conversations. So if you have a favorite Disney character, go ahead and toss that into our comments down below. We want to hear from you guys. We're big Disney fans. We were talking about copyright protection, and that is one of the best things to discuss with that. So now is the time to get in our comments and let us know. So, Tony, introduce yourself. Tell us a little bit about you because you are not only one of the leading experts on trademarking, on copywriting, on IP and entertainment law, but you do so many things. So, what all do you do?
Well, first off, I'll Venmo you the $50 later after the stream ends. But of course, thank you, Cam, for the intro. So my name is Tony Illiakostas. I am actually, as Cam mentioned, my more of my full-time job is I work at ABC News, managing our rights and clearances team. We license all the photos and videos that you see in the news broadcast. So it's a lot of great, humble work that I do in terms of being the broader part of the storytelling process, especially as a news organization where we do try to tell as effective a story as we can, whether it's local, national, or international. But the thing that I am very passionate about, as Cam alluded to, is intellectual property. My day-to-day work is primarily in the copyright space, but I really do love all things intellectual property. And so I've kind of taken an aspiration, something that I've really taken near and dear to me from my academic studies at New York Law School, which is where I graduated. And I've basically used that in sort of a pay it forward type of way where I'm actually an adjunct professor at New York Law School. I'm entering, actually, I just am wrapping up my 5th year teaching entertainment law at New York Law School. We'll be starting my 5th year of intellectual property at the school as well. And I really love teaching all things IP because I think it's the one area of law that everyone has had some type of exposure to in one way or another. In the music that we listen to, in the movies we watch, in the television shows that we watch, even in the technology that we use on an everyday basis. And that even goes beyond, let's say, the cell phones and the laptops that we use, but maybe even the buttons that we press when we're using the treadmill. Everything under the sun has some connection to intellectual property law. And so I've taught intellectual property and entertainment law at New York Law School now for 5 years. And I have an Instagram and TikTok page called The IP Professor, where I've basically taken the way I teach IP and entertainment law and I've brought it to a social media platform. So you kind of get pretty much the inside scoop of how I teach those classes on those forums. So if you're interested in following me, you can check out my TikTok and Instagram pages at the IP Professor. And if you're into podcasts, I actually host an entertainment law podcast with my co-host Evan Nahr. It's called End Scene, an entertainment law podcast. It drops every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
And Tony is a frequent guest on my shows as well, where we have so many conversations about how AI is impacting the entrepreneurial industry. So, Tony, I want to dive right in because I'm really excited about this conversation. This is one you and I have a lot. There's so many good questions surrounding this. We're going to talk all about how AI is impacting copyright. So, from a legal perspective, what is happening to the landscape of copyright protection when it comes to artificial intelligence and content creators?
Well, I can tell you short answer is that the copyright space is being challenged as we speak, but it's not going to go down without a fight. So, and generally speaking, the whole discussion of AI that we've had in the last few months, obviously, Cam, you and I have had that discussion, but for everybody else that hasn't watched those videos, um, the main discussion that has come up with artificial intelligence and copyright is there a world where something that is generated using artificial intelligence can be protected under copyright law? So we're talking about the photos that you would generate on DALL-E or Midjourney or Stability AI. We're talking about the poems or the screenplays, or maybe even some other type of writing, writing, whether we're talking about a novel or anything of that sort on ChatGPT, anything of that sort. Could that generative AI work be worthy of copyright protection? And that gets to the broader discussion of what copyright is. So copyright is an original work of authorship that is fixed in a tangible medium of expression. And the three buzzwords that I always tell my students to pay attention to are the fixation, originality, and the works of authorship prongs. Fixation means that something can be perceived for more than transitory duration. So in other words, there's some level of permanence. So if I were to draw a stick figure on a paper with an actual, permanent marker, that has permanence. It's a permanent marker. You can appreciate that image on a piece of paper for life, basically. Even if I were to draw that on a whiteboard, same story. It could be perceived for more than a transitory duration. Originality is an extremely low threshold in the legal space. You literally can just do a stick figure with a mustache, and our justice system will say, you know what, that is original enough. So it's definitely something that literally you don't have to be a Picasso, a Van Gogh, any sort of high-end artist to make something that would qualify as original. And then, of course, works of authorship gets to the heart of what type of work could be covered under copyright law. So film, television shows, architecture, sculptures, artwork, anything of that sort would be protected under copyright law. Even choreography and pantomimes is covered under the Copyright Act of 1976. Now, in that breakdown, though, the one thing that is not addressed there is the whole essence of human authorship. And that is alluded to in a bevy of different case law related to this subject matter, and was even assessed by the Copyright Office in recent decisions related to generative AI. So what the Copyright Office takes a position on, and what our legal system through case law has taken a position on, is that the only entity that can make a copyrighted work is an actual human being. There needs to be substantial human involvement in order for a copyrighted work to get some type of protection. Now, the degree of substantial human involvement, that's open for debate. It could be 50%, 51%, 52%, may even be 60, 70, it may be even less. Who knows? We just don't have that exact number because we just have not been prescribed a number yet. All that to say, that has been a consistent discussion and a consistent talking point when you're talking about protecting copyrighted works. So basically, in order for a copyrighted work to get protection, it has to come from my mind. I have to have that idea and I have to express it in some form. And that's the complexity with generative AI as we speak. Right now, generative AI lacks that substantial human involvement. This is coming straight from the US Copyright Office. This is coming straight from a very important decision that just happened in the District Court of the District of Columbia, Thaler versus Perlmutter, where the court basically said that generative AI works cannot be protected under copyright law because they lack substantial human involvement. So that's where we stand on it, generally speaking. Will that change? It's very hard to say exactly how it will change or when it will change, but I think change will come. It's just a matter of how the case law develops, how the Copyright Office continues to assess this matter, and moreover, even if legislation passes that says one way or another, AI works can't get copyright protection, or AI works can't get copyright protection, but on these limited terms, basically it's a grab bag at this point, but it will happen at some point. Right now, it's just pretty consistent. Generative AI works are not going to get copyright protection.
And that's incredibly important for creators to keep in mind as they are leveraging the tools and the programs that are created by AI to make our lives a little bit easier. Content created by them cannot get copyright protection, so we have to be wise about when we are using those resources. So, Tony, let's talk a little bit about using those resources. Are we going to see some challenges coming up for content creators knowing that we are not going to be able to get copyright protection for using those programs? Is there a way around it? What should we be thinking of as content creators?
And this is a great question. I think right now we have to sit back and essentially argue that AI, we can't deny that it's innovative in its own way, right? The way it is able to answer prompts, the way it's able to compose certain images, the way it's supposed to do things is very impressive. And it's certainly light years ahead of what we had even anticipated maybe 5 years ago. All that to say, right now we have to take the position that whatever can be generated using artificial intelligence should be treated simply as a source of inspiration and not as a tool. And ultimately, that is the great divide that exists in the creative community. Some people love AI because they do say that it's no different than using a Photoshop, than using Microsoft, Office, tools in some way. It's no different than using Final Cut Pro or Adobe Premiere or any other software out there. They're arguing that a ChatGPT, a DALL-E, Midjourney, Stability AI, those are all just tools. That's not essentially what the other side says. The other side would argue, well, it's not really a tool because you're asking the system to do the work for you. Versus if you were on Photoshop, you click the brush and ultimately it's your finger that is clicking a mouse, or if you have a tablet with a pen, it's ultimately your hand that is doing the movement on Photoshop. The Photoshop is not automating that process. And essentially that automation discussion is what is leading to this great divide here. All that to say, if you are the type of person or the creator that really does rely heavily on artificial intelligence or really wants to use it in a more proactive manner, be wise with your choice, because at the end of the day, again, the way it's assessed from a legal perspective is that anything generated using artificial intelligence will not get copyright protection. So if you're the type of creator that really doesn't care about copyright registrations, which pains my heart, but if you don't care about it, then fine, have at it with AI. Be my guest. It's all, do you do you, boo. But if you are the type of person that highly covets your IP, wants to protect it, and you're doing so because you're trying to prevent other people from infringing on the work, that's where you have to have a different lens to look at here. And that's where you have to basically ask yourself, I should use AI, but let me use it as a source of inspiration to come up with ideas. Let me use it as a way to just think of something. I have a writer's block or I have creator's blocks. Let me just use it as a way to inspire my mind to come up with something brand new. That way, if you use it as a source of inspiration, you still can make something out of it, but still everything is deriving from the human mind and you're still satisfying the human authorship requirement. Now, if you're also the type of creator that, let's say, uses you take a photo, but then you go on Photoshop and you use, let's say, the generative AI fill feature now that is available on Photoshop, that's where it can get a little bit of a gray area, because yes, you took that photo. Yes, at the end of the day, you are the author of it and it is satisfying the substantial human involvement prong. But is the use of the generative AI fill feature on Photoshop to fill out all the other spaces, is that enough to invalidate the copyrightability of that specific asset? It's hard to say, or hard to give an answer rather, because we just don't have that answer. The Copyright Office hasn't said one way or another if a little bit of AI use is going to invalidate the whole completed work, or if it's just going to protect whatever was authored by a human author. So that's the kind of thing where we just have to sit back and wait to see what the Copyright Office comes up with. But that would be essentially my sound advice to any creators out there that are thinking of AI. Just use it as a tool for now. Use it as a source of inspiration, but you don't use it as the end means. Don't use it as the end all be all, because right now the way the AI discussion looks within the copyright space, it doesn't look really that great, and it's not painting the best light as we speak. I think change will happen, but right now, I think it's a little bit too risky to rely so heavily on artificial intelligence.
And we have full playlists on both of my YouTube channels with Tony talking about the legal, ethical, and creative side of using AI as an entrepreneur so that you do not have to use it in ways that could invalidate your copyright, but you can still use it to save yourself time and effort. We were on earlier here on the V Live channel with Irene Chan, and she was talking all about using AI to help go through your content and understand it better, using it to go through your results on something that you've done to pull out things that are important that you can then reuse. It talks about how you can be using it to evaluate your business and the different things you're doing inside of your marketing. And so there are tools where it is creating things for you, and then there are tools where it's helping you to understand your business better and allow you to do new and creative things without invalidating your copyright. And so we get a lot of questions on how we can best be using these AI tools to make sure that we are safe and protected. And we kind of we talked about taking precautions when it comes to using AI so that we are protecting our copyright and our intellectual property. But one of the questions we get a lot, Tony, is about fair use. How does fair use intersect with AI generated content? What does that look like? Can you break down fair use? Because I know there's so much confusion surrounding fair use.
I should also add that there are too many people using the word fair use. It is, I will go to my grave saying it. Um, it is the most used and abused term in the intellectual property space. I cannot begin to tell you how many times I go on YouTube and looking for a movie clip to show to my class, and there are people other than, let's say, a Fandango or the studio's YouTube page, let's say Joe Schmo 95 uploads a 10-minute clip from Avengers Endgame or a 10-minute clip from The Godfather or 5 minutes from Sound of Music. And so they'll write in the caption, fair use, no copyright infringement intended, no copyright infringement intended. If I had a buck for every time someone said that, I would be a millionaire right now. Still be talking to you, but still be a millionaire. Either way, the discussion of fair use is something that's very tricky, and I think a lot of people have not conceptualized uh, in it at all. I don't think that there's any person out there, any lay person, who has used fair use in a very reckless manner and understood its inherent meaning. So there are some people that say that fair use is kind of like a carve out to copyright infringement. Some people say that it's a defense to copyright infringement. I argue that it's a defense to copyright infringement. Someone accuses you of using their copyright, that's when you can use the fair use defense. Fair use operates as defense to copyright infringement so long as, operative words there, so long as you are using someone else's copyrighted work for criticism, commentary, news reporting, teaching, scholarship, or research. Those are the 6 prescribed uses that would protect you under the Copyright Act of 1976. Obviously, some people are thinking in the comments, oh, well, where does parody fall into that? Parody is a type of criticism or commentary, so it's still under this broad umbrella. That said, this is what I tell my students all the time. The step 1 of every fair use argument is to ask yourself, am I using someone else's copyrighted work for criticism, commentary, news reporting, teaching, scholarship, or research? If I am not using it for criticism, commentary, news reporting, teaching, scholarship, or research, that's when I quote the good old community chest card from Monopoly: do not pass go, do not collect $200. It is not worth your while to go through a whole fair use argument and analysis when you know legitimately that you are not using someone else's copyrighted work for any of those permitted reasons. Now, if you are, then there's a 4-factor test that is assessed under the Copyright Act of 1976 that obviously you don't have to satisfy all 4 factors. In fact, the Supreme Court has said that satisfying 1 factor under the fair use doctrine is enough to argue for the whole thing as being a valid fair use. But that said, the information is going to always be fact specific, and it's going to differ case to case. So there isn't like a cookie cutter model that says, oh, guaranteed this is going to work in all fair use situations. That said, the way certain factors lay out in a specific case will move the needle one way or another for or against fair use. So you look at the purpose and character of the use. That's where you lay out what is the commentary, what is the criticism, what is the news reporting. Be specific. Also, the courts look at how did you transform that original work of authorship in your work such that you gave the work new expression, meaning, or message. In effect, you created a new copyright. How did you do that? How did you transform it? That's going to be very subjective, not objective, and that's all going to depend on what the facts lay out in a specific case. look at the nature of the copyrighted work as the second prong. You look at the amount and substantiality of the copyrighted work used in proportion to the whole work. So if, let's say, you lifted 10 seconds from a 3-minute, sorry, rather from a 3-hour film, how did you use that 10 seconds? That's a very small amount. That's not necessarily going to raise a red flag. But even if you use, let's say, 5 minutes from a 3-hour film, that could potentially raise a red flag, because even 5 minutes is a substantial amount. Not maybe in proportion of the whole work, but it's still pretty significant. And then you look at market harm. Is there any sort of harm that the original copyright owner is going to suffer as a result of your use of their copyrighted work? All that to say, the fair use discussion with AI is very tricky, and this is actually being adjudicated in real time in a lot of different lawsuits, especially against OpenAI. A lot of you may be in tune with current events related to the subject, this headline, where authors like George R.R. Martin, like Sarah Silverman, are all part of these massive class action lawsuits against OpenAI, arguing that, in effect, these OpenAI bought their books and ingested the books and the synopsis and all the information into their servers, that then allows platforms like ChatGPT to regurgitate info related to the book and maybe even create new works that are either near identical or maybe mimic in some capacity what these original authors had authored, and spend a lot of time, effort, and maybe even money creating in writing these books. Obviously, the default argument that an entity like OpenAI is going to make is, oh, well, we're not really committing copyright infringement. It's transformative fair use, because we're taking that original work and we're transforming it in some way. Or we're not infringing because we're just giving it some information that would allow the server to naturally come up with the information. All that to say, I don't buy that fair use argument one bit, and I think that that's going to be the heart of a lot of AI lawsuits going forward. Generative AI at some point has to draw inspiration from source material, whether that's source artwork, source writings, whatever it is, whatever it's looking like, it has to pull from something. It's not like an engineer is sitting back behind a computer typing away and saying, oh, well, this is what a Van Gogh painting looks like, or this is the style of John Grisham books. It's not really going to do that. It's going to actually ingest that material. The bottom line is, it's going to be up to these generative AI platforms, these developers like an OpenAI, to sit there and actually look with a straight face at the judge and say, this is fair use. And it's going to be up to the judge to either agree with that decision or completely deny it. I can't sit here with a good conscience. Someone has taught IP and entertainment law for 5 years, who makes IP content on a daily basis. I can't sit here in good conscience saying that the fair use argument is going to hold weight in a court of law when it comes to generative AI. It's too risky. I'm just not buying it. I don't see any of those permitted reasons as enough to move the needle forward in favor of some type of fair use assessment.
And if you are joining us live and you have questions for Tony, now's a great time to go ahead and drop those. We are going to be mindful of the comments. And when you leave a comment, you are going to be entered to potentially win today's giveaway. We are going to be giving away, and I'm so excited about this, a free live streaming mentorship session. You do not want to miss out on this one. This is going to be packed with great knowledge. So the more you comment, the more likely you are to win today. And Tony, one of the things that you and I discuss a lot on our episodes over on my YouTube channels is that there is a difference between generative AI and assistive AI. And that's something we haven't talked about here today. I want to break that down just a little bit, because we've been talking about how you cannot copyright protect anything that was created by AI. But it doesn't mean you can't use AI inside of your business. And it might be a good idea for us to be cautious of generative AI while embracing a little bit more of that assistive AI. So can you break those down for us?
Yeah, so assistive AI, I think, is the type of technology that, if I had to define it from a legal perspective, is not enough to completely overthrow the whole definition of what makes a copyright a copyright. It doesn't have, I think, enough legal weight to say that it completely dismisses the substantial human involvement prong. It's just a type of smart technology that makes it a little bit easier still for the human author to do some type of work, whether that's editing video, editing a photo, writing some type of script or novel on Microsoft Word, something like that. That would qualify as, that type of medium, or those media, would fall under the realm of assistive AI. So some examples of that: let's say that you're on Word and you're typing away and you have a lot of spelling errors. Spell check would be a type of assistive AI where the system knows that when you wrote BRID, you meant to write bird, not brid. So it's going to tell you, hey, fix this to the word bird. Or if, let's say, you were doing some type of editing on Final Cut, but the saturation is a little bit low, let's say the brightness is a little bit too high, whatever it is, you can literally put in certain effects, drag and drop into the clip, and be able to adjust your levels as you see fit, through the lens of you, the filmmaker. Again, it's still you, the author, making that work. You're just making some modifications, and it's still not enough to invalidate the human authorship requirement. That is the inverse of what we're talking about with generative AI, where literally when you go on OpenAI and you say, write me a book about a boy who smelled like cheese, but at the end of the day, people learn to embrace him and make this a really good coming of age story. And then the system creates the entire novel. That is generative AI, because you didn't sit there and write out the entire the script of what the story was going to be like. You didn't go into any length whatsoever. You made zero effort in making that work. In the same way, you go to DALL-E or you go to Stability AI, create a painting in the style of Van Gogh of a dog eating a hamburger while riding a bicycle. And then it generates all these different images of exactly what you asked the system to create. Notice what I'm talking about. The creation is coming from the system. And that's where it gets back to what I was talking about with generative AI and automation. That is what makes generative AI such a painstakingly difficult and excruciating point within the copyright space. There isn't enough there to say that that is worthy of copyright protection, because there's no human author making that work. There's no human author writing that book about the boy who smelled like cheese. There's no human author involved in the creation of that dog eating the hamburger painting. Nothing. It's all coming from the server, and it's all making that creation based on other information that the server itself has. It creates it, and then in the aggregate, it puts out the output that then you become the owner of. And that's the other thing. The terms and conditions of a lot of these platforms say that the output, whatever comes out, makes you the owner. But notice that they don't even explain whether you're the physical owner of the asset or if you're the copyright owner of the asset.
Yeah.
Of course, we all know the answer. You're just the physical owner of the little JPEG that comes out when you go to DALL-E or Stability AI. You are not the copyright owner. And if anyone told you otherwise, I tell them go to the US Copyright Office. We've got tons of decisions coming on that point.
And it's always important to be reading the terms of service for any program that you are using so that you understand what that is going to mean and what implications it's going to have on your business. And more so than that, it's incredibly important to have a lawyer on your team to guide you through this process, especially if you want to protect the work that you are creating, and knowing the difference between generative and assistive AI and how you can best be using that on the legal, ethical, and creative side of entrepreneurship. As always, if you have questions, Tony is our person. You can always reach out to him on social media. You can drop your questions here. We're going to get to that in just a second, but I do want to remind you that we are celebrating VLive's 7th birthday. If you are hearing the noise, that little clapping noise, that's my puppy. She's agreeing with us here. Today is just such a fun day to celebrate VLive, and they are giving you 2 years of VLive for the price of 1 year. We are dropping that link in the comments for you down below right now. This is even better than the deal that they give you on the website. It's even better than the deal that they let me give you. So now is the time to go ahead and grab that. That is 50% off, guys. That's huge. And we want to make sure that we are doing our fantastic giveaway as well. We are just about to do that. You've got about 5 seconds left to get your last comments in if you want to be entered to win our giveaway for our live streaming mentorship with Grant. You do not want to miss out on this one. It is such a good and valuable resource for you if you are getting into live streaming, or if you've been in live streaming and you want to tweak and refine what you're doing. Grant is the guy. So make sure you are getting those final comments in. We're going to draw that in just a second. And if you want to start leaving your thank yous for Tony, that's also a great way to get entered for the prize. You can double up on that one. So go ahead and let us know how much you enjoyed today's episode and that you want Tony back for upcoming episodes. And if you want more of time with Tony, you can always hang out with him on my YouTube channel. It's youtube.com/KMRobinson and youtube.com/KMRobinsonBooks, where he is bringing us the legal side of entrepreneurship and the legal side of publishing, as well as Tony's social medias. Tony, before we do our drawing, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor. And again, you can check out my entertainment law podcast called Unseen. New episodes drop every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
And you do not want to miss out. He has such fun content and he does it in a way that's so accessible because the legal side of things can be so high level. There's a lot of words we don't understand, but he breaks it down so
Oh,
that
too many words.
I know, everybody can understand it though. And he's really good about answering those questions. So if you have further questions, now is the time to head over to his social media and start dropping them. Give him some content ideas. He will do all the great videos for you. But before we get there, we need to draw today's winner. So cross your fingers. Everybody get ready. We're going to go ahead and we are going to pull today's winner. And Be Live can't win their own. So we're going to go ahead and we're going to, oh, congratulations. You have won one mentorship with Grant. He's going to help you break down your live streaming to make sure it is exactly what you need it to be successful, to grow your community, to build those conversations. Grant is such a fun person to hang out with, and he's coming on to the shows that we are doing all week long. He's going to be here to give us such great and valuable information to help us grow what we're doing with our live streaming, so you do not want to miss out. Like I said, we have multiple episodes coming out over the next couple days. We have one more with me today. That's going to be at 8:30 p.m. Eastern. So a few hours from now, we are going live. We're going to be talking with another artificial intelligence expert. And then we've got all sorts of really great business live streaming people coming on the rest of the week, ending in a big celebration in just a couple of days, hosted by me and by Grant. And we are so excited to wrap up the celebrations with you. We are so excited for celebrating Be Live's 7th anniversary birthday. I've been with them from the very beginning. They're giving you 2 years for the price of one. We're dropping it one more time into the comments, and we hope that you will stick around because we are coming back with more episodes for you. Tony, any last thoughts for people on the legal side of using AI?
Just generally speaking, I think that where we are right now with AI, especially generative AI and the copyright space, it is very murky. A lot is to come. I'm sure that we're going to see even some decision come down from the Supreme Court level. That said, again, going back to what I said, we can't ignore the innovation that comes with AI. I'm not sitting here sounding like Bobby Boucher's mom and saying, AI is the devil. Like I'm not doing that at all. But we still have to be cautious. And if you're especially someone, especially a creator, that values protecting your work and you want to prevent other people from infringing on your work, and you're relying heavily on artificial intelligence, that's where you have to be very cautious and very tricky. So again, use AI as a tool, or as a source of inspiration, not as a tool, not as the replacement to you, the actual human mind making that work of authorship. But if you ever have any questions about artificial intelligence and copyright, or if you're a creator and you're trying to figure out a crafty way of navigating the space, obviously I would be remiss if I didn't suggest contacting your lawyer, especially someone who specializes in copyright law, that can help you walk through all the matters or all the questions that you have related to the subject matter.
As always, we want you to be safe and legally protected with whatever you're doing in the entrepreneurial space, from your live streaming to using AI, and making sure that you have a good lawyer, good representation in your team is of the most importance when it comes to protecting your business. Tony's a great resource and a great help to direct you to find that perfect person for your team as well, and to ask those questions in real time. And we will be back with even more experts like Tony in the coming hours and days. We're so excited as we are celebrating, and we hope that you are having fun celebrating with us as well. Let us know what else you would like us to cover in this birthday extravaganza special we are doing all week long, and we'll see you in the upcoming episodes. Until then, have a great day, everyone.
Take care, everybody.